It's good to be back. I was away the past couple of weeks, and I know that you were greeted by some old familiar faces on this webinar. And we really appreciate Adam and Pete Jones stepping up and being with all of you the past couple of weeks. But we have another excellent lineup for you today. But before we get to that, I did want to mention once again the breakfast briefing that Bond's Labor Department is currently putting on across the state. We've had 2 sessions take place already. We were in Binghamton, and we have some of our members of our team here out in Albany today. But the feedback already has been very positive. My understanding is that it's a very interactive presentation, really an opportunity not only to learn from us on handling these really difficult issues, but from each other. So hope that you will take the time to register and come attend one of these sessions this fall. So moving on to today's program, however, we are traveling the upstate New York thruway as we often do here at Bond. And so we're going to start in Buffalo with Seth Gilbertson, our frequent contributor, who's spoken with us before about pay transparency, but now it's in effect, now it's law. And he's going to tell us about the new regulations. After Seth, we'll move to the other end of the thruway to Rebecca LaPointe in our Albany office to talk about some new proposed regulations on the white collar exemption. Then back to Syracuse. Tom is back with us. Tom Yaron is back with us after just being with us very recently, talking about a significant decision in the world of workplace retaliation. And finally, we'll talk about some tax issues with Frank Mayer out in Albany. So with that, I'll turn it over to Seth Gilbertson. Thanks, Seth.
Thanks, Kristen. Hi, everyone. I'm back, as Kristen said, to talk about pay transparency again. This time we have an actual statute that's gone into effect on Sunday. So while you were all watching football, there was the pay transparency went into effect. And next slide, please. We're going to talk about that, the fact that it went into effect, some quick reminders as to what we're talking about. Essentially, the law applies to all employers with 4 or more employees in New York. There are some very limited exceptions for temp employers, but for the most part, it's going to cover almost everybody. Requires us to disclose a range of compensation as well as a job description if one exists. I'll talk about that in a minute. And there can be up to $3,000 per violation penalties issued by the Department of Labor. The Department of Labor can bring an action to enforce the law on its own, or individuals can make complaints to the Department of Labor, which it will then investigate and potentially issue fines. Next slide, please. So the law applies to the posting or advertising is the term that the law uses. Any job, promotion, or transfer opportunity that will be physically performed in New York, or remote jobs that will report to a supervisor or office in the state of New York. And again, it applies to advertisements, which include essentially any written description of the opportunity for employment. Next slide, please. All right, so we have some proposed regulations, and in typical New York fashion, the regulations came out exactly 4 days before the law went into effect. Now, these are only proposed regulations at this point. We won't get actual regulations or the final regulations for probably about 3 months, something along those lines, probably around the end of the year. We'll have actual regulations, but almost just a couple days after the rulemaking, the regulations were announced. The Department of Labor came out with guidance documents, including a FAQ and a fact sheet for employers and a fact sheet for employees that essentially act as though the regulations are already in effect. So basically, the Department of Labor had said, here's how we'd like to interpret this law. And by the way, we're already interpreting the law this way. So we have proposed regulations, but we have actual guidance, and the administrative fiat state is in full effect here. And there are, for the most part, these regulations confirm the things that we've been telling our clients and employers all along. There are a couple areas that we'll point out that where they provide maybe a little bit more insight, and a couple areas where they go a little bit further than the a strict interpretation of the statutory language would seem to indicate. So for range, one of the areas that the regulations and proposed guidance, or the proposed regulations and guidance, provide a little bit more insight is that they state that the range must be limited to a single opportunity in a single geographic location. Now, what does that mean? If you have a position where you are posting for, let's say, an associate and an assistant level position in the same job posting, and there are different salary ranges for those two positions, you need to provide both salary ranges. You can't just lump them into one. If you are hiring for a position upstate and a position downstate, and you are paying differential salary based upon the cost of living in those areas, which is fairly common, then you need to provide both salaries depending on where the geographic location of the position is going to be. So essentially, you need to narrow the scope of the position in order to fit the range that you are attaching to that position. The proposed regulations and actual guidance give us a little bit more insight into what good faith means, and good faith is the language that the statute uses to say how you are to determine the range. So you need to make a good faith estimate of the range of compensation that you are planning to pay for the opportunity when you fill it with with an applicant. They say you can include job market, current employee compensation levels, hiring budget, experience and education levels. This is very much consistent with what we've been saying all along. The other thing that we've been saying is, when we're asked the question, can you pay the ultimate successful applicant outside of the range that you had posted? And surprisingly, somewhat, the proposed regulations and new guidance say that you can. They suggest that you should repost, but say that you can pay outside if you've learned something new through the hiring process or received an applicant that you did not expect that may demand a higher salary based upon education or experience levels or something like that. Now, what we've been telling people, and what I think we would continue to tell people based upon the proposed regulations, is that you should document the reason for that, so that if anybody questions it later, you can show that at the time you posted the range, that was your good faith expectation, and then that expectation changed based upon information that you obtained or learned about through the hiring process itself. The regulations also suggest that the range can be so broad as to constitute a violation if the range is broad enough that it doesn't actually give an individual clear information about what the position is going to pay. So I think we can all kind of imagine where that would lead if you have a range that is, within maybe multiple tens of thousands of dollars, $40,000 to $120,000 or something like that. I think that would create a red flag, because there's such drastic differences between those two values of compensation that it doesn't actually tell the individual applicants all that much about what they might actually be making. Next slide, please. Advertisements must also contain a job description for the opportunity if a job description exists. That is what the statute has always said. The statute, I'll just read you the language real quick, says the job description for such job promotion or transfer opportunity if such job description exists. Now, the guidance in the FAQ, I'm sorry, in the fact sheet says job descriptions. An employer must create a job description except in the limited circumstance where the title conveys the job duties. The example they give is a dishwasher, who only washes dishes. So as you can hear, the differences between the actual language of the statute and the guidance, it is rather different. The language of the statute does not in any way suggest that you are required to create a job description. The guidance suggests that you are indeed required to create a job description, except in the limited circumstances where the title of the job essentially conveys all the information that you need to know about what the individual is going to be expected to do. Now, that they may get some pushback on the proposed regulations since they go pretty far beyond what the statutory language is. We'll see about that, but the guidance is already out there. The upside to this, it's a little annoying when they go so far outside of what the statutory language that was passed by the legislature and signed by the governor says. But the upside is we've been advising people all along that they should have job descriptions for most positions. It would be the extraordinary position where you wouldn't want to have any kind of description. There are lots of secondary benefits to having a clear job description in terms of performance evaluation, determining essential functions when there are accommodations being provided, things like that. There are reasons to have job descriptions. This is now another reason that the Department of Labor is essentially saying that you have to. The proposed regulations and new guidance also define a pool of applicants, which pool would sort of conjures up images of a group. The group only needs to be more than one. So when would this come up? This would come up on the general posting. It would never come up. But if you were doing direct outreach to individuals, let's say you send an email to someone saying, I have this new job, I'd like you to apply. That's one person. If you send two of those emails, then you need to include the range in there because now you've advertised the position to a pool of applicants. So pool of applicants means more than one applicant. And then finally, another helpful bit of information that the proposed regulations provide is to say that incidental or infrequent presence in New York. So this is, I imagine, someone who maybe your corporate headquarters is in New York and you're employing somebody in Pennsylvania and they need to come in twice a year for departmental meetings or something like that. That is not going to constitute physical presence in New York for purpose of application of the salary transparency law. Same thing if you have someone who maybe has a Northeast region is their area of responsibility and they sometimes come through New York because it's in the Northeast, but they are actually located in New York physically located in New York for purposes of doing their day-to-day job activities. Next slide, please. All right, so I went through some of these issues already, but these are the common questions that we've been getting over the last few months as we all anticipate the salary transparency law going into effect. Does it apply to public entities? No, it does not. We've been saying that all along the regulations. We've been saying that based upon our own interpretation of the statutory language, but the regulations do confirm that the law does not apply to public entities. Do you have to create a job description? I just talked about that. The statutory language says no. The guidance and regulations say yes. So, but again, we've been advising people to create job descriptions or have a job description in place already, even if it's just a brief one, because there are secondary benefits to that. Does the law apply to advertisements that were posted prior to September 17th? I would say it is safest. So the law is a bit unclear on this one. I would say that it is probably the safer practice to add ranges if you have live postings out there and you can do that. That being said, I think we could probably come up with a pretty good argument that at the time of the posting, the law wasn't in effect, and that is the act that is covered by the statute. But I'd rather not have to make that argument, frankly, to the Department of Labor. So could we defend not adding a range to a posting? Yes, I think we could, but I'd probably rather not defend that, not face the regulatory investigation or penalty attempt by the Department of Labor. So if you can add ranges to existing live postings, I would do so. I would recommend that you do so. Do you need to include benefits? No, you do not need to include benefits. However, you can include benefits. It's optional. I imagine most employers probably would like to at least suggest that there are benefits related to the job if there are, because that's going to help attract a better pool of applicants. And then do you have to advertise every opportunity? No, nothing about this law requires that you post or advertise a position. You can still use direct recruiting, promotions, things like that. Although again, if you reach out to more than one individual, then now you've created an advertisement under the law, and you would have to notify the individuals that you're reaching out to about what the range of compensation is going to be for the position. But nothing requires that you post every position or advertise every position. You can still just promote somebody or just go out and hire, somebody directly that you've been working with that you think is going to be a good fit for your company or your position. All right, thank you very much.
Thank you, Seth. And so appreciate that update now that it's real, especially. And I know there's many questions brewing out there, which sometimes only come up after you start doing something, right? And you realize what you don't know. So appreciate that. Next, wanted to turn to our associate in the Albany office, Rebecca Lapointe, who is going to talk about the U.S. Department of Labor's new proposed white collar exemption rule that came out recently. Thanks for joining us today, Rebecca. Welcome to the webinar.
Thank you, Kristen, and thank you everyone for joining today as well. Next slide, please, Kathy. So we'll be talking about the proposed rule for the white collar exemptions by the U.S. Department of Labor. This proposed rule was issued on August 30th, 2023. The proposed rule would increase the minimum weekly salary to qualify for the Fair Labor Standards Act executive, administrative, and professional white collar exemptions from $684 per week or $35,568 annually to $1,059 per week or $55,068 annually. It also proposed an increase to the annual salary threshold to qualify for the highly compensated employee exemption from $107,432 to $143,988. And finally, it will establish automatic increases to these salary levels every 3 years. Of note on that point, the proposed rule includes a provision that would allow the department to temporarily delay a scheduled automatic update where unforeseen economic or other conditions warrant. Next slide, please. Notably, the proposed rule does not include any changes to the duties requirements for any of the white collar exemptions. And there are also no changes for employees whose exemption status is determined only by the duties tests. So doctors, lawyers, and teachers. The Department of Labor estimates that 3.4 million currently exempt employees who earn at least the $684 per week, but less than the proposed standard salary level of $1,059 per week would potentially be entitled to overtime pay with these new regulations. So next slide, please. Looking at the timeline of when this could potentially go into effect, the proposed rule will be open to public comment until November 7th, 2023. We do not know the exact timeline for the DOL's publication of a final rule or when a final rule might go into effect. But by way of an estimate, the time between the 2019 proposed rule and the final rule was approximately 10 months. This could potentially occur much sooner. Next slide, please. We also anticipate that there may be some legal challenges to the rule if it is ultimately adopted. This occurred in 2016 when the Department of Labor issued a final rule increasing the exempt salary threshold to $913 per week. In that case, the United States District Court for the Eastern District of Texas issued a nationwide injunction prohibiting the Department of Labor from implementing the final rule, and the rule was formally rescinded. Next slide, please. So looking at some key takeaways, if this proposed rule is adopted, employers that use housing or meal allowances to meet the New York salary threshold will still need to ensure that the new federal salary threshold is met because the federal minimum salary does not count housing or meal allowances. The New York exemptions do not set a minimum salary level to qualify for the professional exemption. So if the proposed rule is adopted, employers will need to review the salary levels of professional employees to ensure they still meet the federal thresholds. Next slide, please. New York's minimum salary level to qualify for the executive and administrative exemptions is currently higher than the proposed level of $1,059 per week in all regions of New York. But notably, the Department of Labor indicated that the actual salary threshold will be based on the earnings data as of the date that the final rule takes effect. So the salary minimum may ultimately be higher than the projected $55,068 per year. So it may potentially end up more closer to the $60,000 annually. So just of note, employers wishing to proactively prepare for the potential implementation of the proposed rule may want to start strategizing how they will treat exempt employees who currently earn an annual salary between $35,568 and approximately $60,000. Again, this is just a proposed rule. Nothing's gone into effect yet, but it could be helpful to be proactive and start looking at salary levels for your professional, executive, and administrative employees. It was a quick one, but thank you all.
That's okay. Thank you for sharing that new development with us, just a couple weeks old at this point. So we'll just have to wait and see what happens. And, you know, we'll provide updates here as things develop. So next thing that we wanted to share with you today, Tom Iran is here with us again. He recently wrote an article about an interesting retaliation case. So Tom, why don't you tell us about it? Thank you for being here.
Thanks, Kristen. Good afternoon, everyone. It might surprise you to know that among the charges that get filed with the U.S. Equal Employment Opportunity Commission, retaliation charges top the list year after year. In fact, more than 50% of all charges involve some allegation of retaliation. And it likewise with litigation that's brought by the EEOC. 30 to 35% of those cases have a retaliation component. And we also find that in litigating these cases, it is more likely that a retaliation claim goes to a jury than an underlying substantive discrimination claim based on race or gender or age, and that juries are more likely to find for plaintiffs on retaliation claims. And there are a lot of reasons for that. It certainly can be difficult for some supervisors and managers to maintain a business as usual demeanor with an employee after they've been accused of some unlawful conduct. And that's what gives rise to the retaliation. So when we see a case like this recent case out of the Second Circuit, Carr against the New York City Transit Authority, that expands the scope of retaliation claims, we stand up and take notice and want to share with you some takeaways from that decision. So fundamental to a retaliation claim are four elements: that the plaintiff engaged in protected activity, that is, they complained about an discriminatory act or filed a charge, participated in an EEOC or other administrative proceeding, that the employer was aware of this protected activity, that the employee suffered some adverse action, and that the employee can prove that the adverse action was caused by the protected activity. In other words, the employer retaliated against the individual, took some action, denied him a promotion, discharge, etc., because they had complained about alleged discrimination or filed a charge with the EEOC or the like. And the two developments come in the context of what is an adverse action that would qualify to make a viable retaliation claim. And the first piece was a recognition by the court that the concept of adverse action, when we're talking about a distinct negative impact on the plaintiff, is much broader in a retaliation context. In the context of age or race or sex discrimination, the various federal laws describe that as discharge, refusal to hire, or other change to the terms and conditions of employment. So it's conduct that is employment-based. The court pointed out that the sections of the law dealing with retaliation don't have that limitation. It is discriminate against the individual because they engaged in the protected activity. So what's the significance of that difference? Conduct outside of the workplace adverse action to the employee beyond terms and conditions of employment can give rise to a retaliation claim. In the Carr case, that was not the circumstance, but you can think of examples. An employee who has complained about discriminatory conduct is looking to buy a house, goes to the bank, and applies for a mortgage. The bank then sends a request to the employer for employment verification information, and that is not completed or completed incorrectly, and the employee does not end up getting the loan and is unable to buy the house. If the employer were to complain that conduct by the employer was discriminatory because they had engaged in the protected activity, this case suggests that that's a sufficient adverse action. And we can come up with other similar hypotheticals, especially in my mind, I'm thinking of small towns where there are relationships above and beyond the employment relationship between the employee and managers and supervisors who work for you. So we need to be mindful that there's a whole other area of conduct outside the workplace that can give rise to a claim of retaliation. The second piece of the decision was focused on retaliation for a hostile environment, and this was core to the Carr case. We know under federal law that one aspect of employment discrimination is this claim of hostile work environment based on gender or race or other protected characteristic. And we know that the established standard for that is that the conduct has to be severe or pervasive enough to alter the terms and conditions of employment. There's a certain bar that the plaintiff has to establish in order to make out the claim. In this recent decision, the Second Circuit said that rule of law does not apply in a retaliation claim. In a retaliation claim, under a hostile environment rubric, the employee needs to show an adverse action, which would be conduct by the employer that would cause a reasonable worker or would dissuade a reasonable worker from making a complaint of discrimination or filing a charge. In other words, would dissuade a reasonable worker from engaging in protected activity. To me, that's a very wide open standard. It's very difficult to get your hands around that concept, and which means it's more likely not to be resolved on motion, not to be resolved on summary judgment. It's more likely to go to a jury who's going to try and decide, would a reasonable person faced with these circumstances be dissuaded from raising their hand, filing a charge, bringing a complaint of discrimination. And as I said at the beginning, the whole reason we focus on retaliation is because these cases get to the jury. The juries tend to be more sympathetic to the plaintiffs on retaliation claims. So for me, this is a significant concern that this notion of a retaliatory hostile environment has become much more of a plaintiff-friendly litigation theory, and one that we need to pay close attention to. So that takes us back to what should we be doing, right, to avoid finding ourselves in this situation. I'm sure that 99.9% of the folks on this webinar have an anti-retaliation provision in their policy, and they have, as part of their regular training on anti-discrimination and fair treatment of employees, discussion of anti-retaliation as a guiding principle for their organization. That's great. Take a step back. Think about how the retaliation claims come to be in the first place. Very often, there is a underlying administrative decision, work performance decision that gets issued to an employee and triggers their concern that they've been discriminated against. Have we adequately trained our supervisors and managers to have that conversation so that the employees understand the justification for the adverse action, the performance improvement opportunity that is being presented to them to try to minimize the risk of the underlying discrimination claim and also the ultimate retaliation claim. Beyond that, when you get the complaint and you're conducting the investigation, critical to include counseling with everyone who participates, the complainant, the witnesses, the individual who's accused of engaging in discriminatory conduct, that they cannot retaliate, and re-emphasize the employer's position and policy on not retaliating for bringing protected activity forward. And significantly, as part of your playbook for handling these investigations, it should include a follow-up, regardless of the result, a follow-up with the complaining employee to confirm that there hasn't been any retaliation or that they haven't experienced or believe that they've been slighted by their supervisor or coworkers after the fact. And clear documentation of that follow-up, so that if in the future the retaliation allegation arises, you've got some record to show your good faith efforts and proof that in fact the complaining employee was not subject to retaliation. This is an area where we have to keep focus and attention because the stakes are very high. And as the case law develops, we will keep you informed. Thanks for taking the time to let me talk to you this afternoon.
And thank you, Tom, very much for that. So we have one last presentation here this afternoon. I almost said this morning, but it's this afternoon now. And want to welcome back to the webinar Frank Mayer in our Albany office to talk about an IRS announcement concerning employee retention tax credit claims. So thank you, Frank, and go right ahead.
Oh, well, thank you, Christian, and thank you everyone for being here today. As if we haven't heard enough about the employee retention tax credit from television and satellite radio, I have some more information to share with you. So as a quick recap, the employee retention tax credit is a refundable payroll tax credit that's available to certain eligible employers that kept people working during and despite the shutdowns imposed by the COVID-19 pandemic, or organizations that face steep declines in gross receipts during the period March 13th, 2020 through September 30th, 2021. Excuse me. So we've posted a couple of information memos detailing the eligibility factors for the employee retention credit over the last year or two. And although the pandemic is long past, eligible employers can still claim the employer retention credit by amending their quarterly payroll tax returns for eligible quarters in both 20 and 21. The eligible form, of course, is the IRS Form 941X, amending the quarterly payroll tax return. Now, late on September 14th, just a few days ago, the IRS announced an immediate moratorium on the processing of new employee retention tax credit claims amid a surge of questionable claims. Now, this moratorium, we're told, will run through the end of 2023, and this will give the IRS an opportunity, well, in my view, an opportunity to catch its breath, or an opportunity to study what safeguards need to be put in place to prevent what the IRS considers further abuse of the employee retention tax credit claim, and to protect businesses from predatory employee retention credit consultants. The IRS also said in its announcement that it'll continue to process and pay out claims received prior to the enactment of the September 14th moratorium, but it's going to give some increased attention to fraud concerns as it processes the returns that it has received prior to that date. So what that means for taxpayers who've made an employee retention credit filing is that the normal period for review has been expanded from 90 days to about 180 days, excuse me. Now, the IRS also said that it will be finalizing details on a special withdrawal program or option for those who choose to withdraw an employee retention credit claim that has not been processed. So over the past year, as you may have heard on, like I said, on television and satellite radio, an uptick in these self-proclaimed employee retention experts, we like to call them pop-ups, LLCs that are formed, 2 months into the pandemic, that purport to be experts on the employee retention credit. And the IRS is well aware of this. They issued warnings in October 22 and again in March 23 to employers to be aware of third parties that may be offering inaccurate or false tax advice regarding the employee retention credit. And the IRS considers this so severe that they added the employee retention credit to the top of its list of annual Dirty Dozen list of the most prevalent tax scams. So that's how serious the IRS is taking this. Now, these consultants have aggressively marketed their services through a barrage of advertisements, as we said, TV, satellite radio, and who knows what else. Oftentimes, these folks want to collect a percentage of the potential credit, whether or not the taxpayer actually files and receives the credit. Excuse me, in late July, the IRS has continued its outreach by publishing a new set of questions and answers on its website, warning taxpayers of potential scammers out there. And some of the examples they provided of things to make a taxpayer wary of a promoter is that the taxpayer gets unsolicited calls or advertisements mentioning an easy application process, statements from the company that, you can claim, qualify in seconds, apply in minutes, and have your refund in hours, those kinds of crazy things, large upfront fees to claim the credit, whether or not the taxpayer actually gets the credit, and then fees based on a percentage of credit claimed. Another telltale sign is that preparers refusing to find the 941X, the payroll tax return. Now, tax preparers are required to sign as preparer when they prepare a tax return. Some of these groups, they'll like to prepare all the numbers and then expect the taxpayer to drop the numbers on a tax return and then have a CFO or CEO of a client sign the tax return, and the tax preparer's signature, the promoter's signature, is nowhere to be found on the return, leaving the taxpayer to face the music alone with the IRS should something go wrong. In reality, determining eligibility for the employee retention tax credit is a complex legal and accounting issue. It's really important for a taxpayer to be certain whether or not they're eligible for the employee retention tax credit before the IRS initiates an audit or a pandemic-related fraud investigation. So as we've explained in our prior memos, and you may be aware, generally eligible employers to claim this credit must satisfy one of two eligibility factors. One is if the entity was fully or partially suspended operations during any calendar quarter due to orders from an appropriate government authority limiting commerce, travel, or group meetings due to the COVID-19, and it more than nominally affected the business. And we'll get into what nominally means in just a bit. Alternatively, if the entity experienced a significant decline in gross receipts during the calendar quarter, in 2020, that meant a 50% reduction in gross receipts from the correlative quarter in 2019. And in 2021, those rules were relaxed a bit to say a 20% decline in gross receipts from the correlative period in 2020, or alternatively, the correlative period in 2019, making it easier to claim the credit in 2021. Now, in the case of an entity that suspended operations to a government order, if under the facts and circumstances more than a nominal, and here's that nominal word again, not less than 10% of the gross receipts or less than 10% of the number of service hours of the business, a reduction by those amounts, the taxpayer would be deemed to have more than a nominal reduction in its operations due to a government order. Now, over the past several months, and actually it's probably more than several months by now, but we've had the opportunity to review a number of reports from some of these employee retention experts. And sometimes we've had the pleasure of dealing with the same promoter multiple times and looking at their engagement letters, charging fees between 13, 15, 18% or more on a percentage of the proposed credit, whether or not the taxpayer actually makes the claim. The analysis sometimes is a little on the light side. For example, some of the things we've seen, as we mentioned, to be considered a government order for shutdown, it has to be an order from an appropriate government authority, from the federal government, a state government, or local government, limiting commerce or travel. And other times, the IRS has come out and said that, if you get politicians at a press conference or an interview on television that talk about suggested actions regarding discontinuing or slowing down activities, that's not good enough. But some of these promoters will grab anything they can and say, oh, that's a government ordered shutdown, which is just not the case. Another common error that we've seen or omission is that what constitutes a partial shutdown, or more than a nominal portion. Sometimes the promoters will just simply make it up or take a position contrary to the IRS Q&A and say things like, well, the employees weren't as efficient, even though they were all working. They just weren't as efficient as they were before, even though they haven't met that 10% threshold in hours or gross receipts needed for more than a nominal reduction in hours under a government ordered shutdown. So if you're a taxpayer that has either filed for employee retention credit or is in the process of filing, we would strongly encourage you to review, particularly if you're working with a promoter that's not your CPA or your attorney, is to have a second set of eyes, take a look at what you are doing or what is proposed by this consultant. Have someone who knows what they're doing review it, because the penalties for the employer as well as the professional, many times a CPA or attorney working for the client will sign the tax return to not only the client's peril but to their own professional peril if something goes wrong and the IRS comes back with a demand for refund or even a fraud claim. So if there are any questions about the employee retention credit, please let me know. Other than that, that's all I have for today.
Okay, thank you, Frank, for that insight. Appreciate it. If you have any questions for any of our presenters, here are the email addresses for each of them. Be happy to talk with you. Thanks for joining us, and we'll see you again here next week at noon.